All right. Good evening. Thank you so much for joining us this evening on what has proven to be a very interesting topic for many of us to want to learn more about. My name is Nicole Story. I have the pleasure of serving as the manager of the City of Charlotte's Community Engagement Division. You are here joining us tonight to learn about exploring corporate buyer deterrence strategies. This is again, a topic that there has been a lot of interest for, and as a result, this training is being recorded. It will be added to our on-demand training library, and for those of you who are with us tonight and have registered, we will absolutely share that information with you, as well as a copy of the slides that you will see this evening. I will be joined tonight by my colleagues Sean Heath and Ben Carb. And additionally, in the background, I want to acknowledge Philip Freeman, who's running tech for us tonight to ensure that we get through this smoothly with no tech challenges. I want to invite you to submit your questions. Your questions are welcome. We've already had a number of questions that were submitted in advance, and they help us to learn as well. So we have reserved ample time at the end of the presentation for those questions. If Zoom is new to you, or if it's been a minute, if you'll look on your ribbon where you have your mute and your video controls, you'll also see a button there that says Q&A. That is the preferred method for garnering questions tonight. If you'll type your questions in that Q&A chat box, that will allow us to ensure that all of the questions are seen and logged and that we have responded to them appropriately. If that Q&A chat box is giving you some troubles, don't worry. Once we get through the questions that are in the Q&A box, we'll look for hands raised as well to make sure that we've addressed anybody who may be having tech challenges or not access to a keyboard or just didn't feel like typing tonight. We'll also address any questions that remain after this session via email or telephone. So we are looking forward to ensuring that we can provide answers on this topic. And with that, it is my pleasure to introduce you to the Director of the Housing and Neighborhood Services Division at the City of Charlotte, Mr. Sean Heath.
Thanks, Nicole, and good evening, everybody. As Nicole mentioned, my name is Sean Heath, work for the City of Charlotte in our housing department. I know with this particular audience, I don't have to tell you that the corporate investor activity really across the country has accelerated over the past few years. And Charlotte has certainly been one of the hottest markets in that regard. So we know this has generated questions and concerns across the community. What does it mean locally? Buying a home in this market is incredibly challenging, particularly for first-time home buyers. So a few months ago, internally, we talked about the idea of setting up an educational session for property owners, community leaders, HOAs, et cetera, really just to try to set the foundation in terms of what's happening in the marketplace and what some options could potentially be for organized neighborhoods to establish some tools or activate some tools to deter this type of activity. So I would underscore that this is really meant to be education in hopes of enabling neighborhoods to better make informed decisions. We're not in a position of advocacy around these issues this evening, but we felt like this would be a good way to get things started in a conversation. Having said that, and even though we have reserved ample time at the end, it's also fair to say this is a very technical and complex topic. And I would imagine at the end of this evening, there will be some very neighborhood specific questions that haven't been fully addressed. I think we should just acknowledge that up front. So one of the things that we'll do after tonight as a team is we'll reflect on the questions we received and how much progress we felt like we made tonight. And then we'll evaluate what kind of additional sessions and resources could be provided going forward. I don't think this is a one and done in terms of a 90-minute session this evening. But we're happy to do it, and I don't want to slow things down anymore. So let me introduce Ben Carb, who is our presenter tonight. Ben is an attorney with Kirk Palmer and Thigpen, and his areas of practice focus cover a few things, but in particular for this conversation, he's very involved in community association law. So he has a lot of experience working with homeowners associations and condominium associations in North and South Carolina. And he's going to set the foundation for us this evening around kind of what's happening in the marketplace and how neighborhoods can think about what potential responses could look like to this type of activity. So with no further ado, Ben, thanks for joining us tonight, and I'll turn it over to you.
Well, thanks, Sean and Nicole. So I'm certainly pleased to present this topic to everybody. It is certainly a complex topic, and one that, the city of Charlotte, Mecklenburg County, and really this part of the country has seen grow exponentially over the past few years. So what I'm going to do my best, at least, to share my screen. I've got a presentation. You'll have access to the presentation afterwards, or maybe it's already available. But feel free to review that. Hopefully you find it helpful. And I'm going to try to jump right in. Let me see here if I can share my screen. All right. I'm hoping you see the first slide of my presentation. I've called it Exploring Corporate Buyer Deterrence Strategies. As Sean mentioned, I'm an HOA attorney, a community association attorney, which means that I represent a lot of HOAs and condominium associations. And as some of you are probably aware, HOAs and condos are sort of the parties that are facing this issue of corporate ownership head on. Before we get into the topic specifically, I want to point out that this is not legal advice. I think if this conversation interests you or your community, you should reach out to an attorney to learn more. This is also not advocacy. We're not really taking sides here, telling anybody what they should or shouldn't do, whether corporate ownership is good or bad. It's just a topic that everybody locally, at least, is aware of right now. So the purpose of this is to educate. So there's a few ways that corporate ownership can be deterred or regulated. There may be other options out there, but the main ones that we have seen are through condos and HOAs. And we'll also talk about deed restrictions, which is more of a historical way of regulating property. But why are we even here today? So corporate ownership and in particular corporate landlords have been buying up property at a rate that we've never really seen before. I've got some headlines on the left column of my slide that are from the Charlotte Observer, basically pointing out that corporate landlords are buying so much property in Mecklenburg County that it's sort of overwhelming some HOAs and some neighborhoods. The real estate firm Redfin estimated that almost a third of all homes bought in the past 2 quarters of 2022, obviously it's 2023 now, but were to corporate investors. And more than 25% of all rental homes are owned by corporate investors. What you're seeing here locally is that you'll get investors with a lot of money out there just making all cash offers to people in subdivisions, and they'll buy homes en masse. They will literally buy 10, 20, 50 homes at a time, usually spread out amongst many subdivisions, but sometimes all of them will be in one subdivision. So you're really concentrating ownership in these landlords, and that's really caused a lot of concern locally. So one of the main ways that real estate is owned here in Charlotte is through a condominium. And condominiums are very unique from a real estate standpoint. I don't intend on spending a whole lot of time discussing condos, but really what a condo is fundamentally is where a person owns their unit, which is essentially a box of air. You could almost analogize a unit to being the paint and the drywall and everything on the inside. And then the structure of the building and the land is part of the common elements. And what really makes a condo unique is that the common elements are owned by all owners collectively. That's something that a lot of people don't understand, but I wanted to just point that out because people assume a condominium is similar to an HOA, where an HOA owns the real estate And that's not actually correct. A condo is where the owners actually own the real estate collectively. And the reason we'll talk about condos is because they're one of the legal structures that can somewhat regulate corporate ownership in addition to HOAs. We'll also talk about several different types of HOAs. And the first that we'll talk about is what we refer to as a mandatory HOA. And it's mandatory because you don't have a choice. When you buy your property, it is subject to a declaration typically, which says that you as an owner are obligated to pay some amount of money to an HOA, which is responsible for maintaining real estate or paying insurance or taxes or some amount of money for real estate that is described in the declaration. Many people think that in an HOA, you have to sign a document to become a member of the HOA, and that's actually incorrect. Once you buy your property, you are a member of that HOA. You really can't, you don't get a choice. So what is the defining feature of HOAs and condos other than just distinguishing between HOAs and condos? The really defining part is that the restrictions run with the land. And what I mean when I say that is they are binding on you and whoever you sell your property to and whoever that person sells it to. We say that it's the documents run with the land so that they cannot be separated from the land. If you buy a condominium unit or buy a house within an HOA, the declaration is binding on you. And I just alluded to this, but it really binds all present and current owners. So it's really something you don't have a choice over. And I mentioned a mandatory HOA. These are typically put in place by a developer. And we have an asterisk next to the word developer because it's possible, very unlikely, but possible, that owners could agree to form a mandatory HOA on their own, although they would need a very high majority of owners to make it effective. So the hallmark is really that owners have to pay assessments. I'm not going to go into that further because I already discussed it, but by statute, HOAs also have to have a minimum number of lots in most cases, and that number is 20 lots. On occasion, you can see smaller HOAs of less than 20 lots, but legally, if you've got 20 or more lots and there's an obligation to pay assessments, then you have to form an HOA. It's a legal requirement. So in essentially every larger neighborhood of 20 or more lots that have been formed in really the past 20 plus years, you've got a mandatory HOA, and that's because it's legally required. So we mentioned, and this is the asterisk, that residents could establish an HOA if they wanted to and make it binding on all owners. But to do that, they really need 100% participation. If you've got 100 lots in a neighborhood without a mandatory HOA and 99 out of 100 agree to it, then that one remaining lot is not bound by the mandatory HOA. You cannot force that person to be a part of a mandatory HOA unless they agree to it. As many of you are probably aware, and as many of you participating may be part of, Charlotte has a lot of voluntary HOAs. And they have different names, but we often refer to them as neighborhood organizations or community associations. And they are essentially optional HOAs that are formed to look out for the interests of owners within a specific neighborhood. I'm sure there's many that I'm not aware of, but some of the ones that are fairly prominent are the Myers Park Homeowners Association, Plaza Midwood Homeowners Association, I believe the Cherry neighborhood near where my office is located has a neighborhood association. And in these neighborhood associations, even though it may say community association or have a name similar to an actual HOA, you're not obligated to be a member. And the reason is, it is not within there's not a declaration that binds your real estate that says you have to be a member of that voluntary HOA. And because of that, it's typically, you basically pay an annual fee to that HOA. And by doing so, you help support it. And then that HOA will then advocate for the neighborhood's owners. But it's not required. You can typically exit it at any time. The problem, or at least for purposes of today's discussion, the difficulty with a voluntary HOA is that they don't have sharp teeth like a condominium or a mandatory HOA. And what I mean by saying that is that they don't have that many legal rights over their members. If you're a member of a voluntary HOA and you don't keep your property in the condition that the members of that HOA want, then the voluntary HOA can really not do as much legally against you as a mandatory HOA could. I'm not going to get into all the details tonight, but a mandatory HOA has the ability to fine a person, to file a lien against that person's property, and ultimately to foreclose that lien. Those are extreme remedies in many cases, but legally, a mandatory HOA has those options. A voluntary HOA really does not. So there's a lot of pros and cons to any decision involving an HOA, and some of these may be obvious, but some less so. I'm just going to sort of run down the pros and cons, and some probably straddle the line. You could argue either way. In a mandatory HOA, you've got a collective voice. The collective ownership basically gives authority to the board of directors to advocate on the owner's behalf. Where owners' voices are loudest is when their HOA speaks on their behalf. There's also a centralized system of governance. And I just mentioned the board of directors, but in a mandatory HOA, what owners do is they elect a board of directors. And that board of directors then makes decisions on behalf of the nonprofit, of the association. That can be things such as buying new landscaping, entering contracts, ultimately doing some of the legal things that I mentioned earlier, filing liens, foreclosing. So power is vested in the board of directors. And one of the benefits of that is if there's a dispute, say, where an owner isn't paying their HOA assessments, the face of the HOA is a board of directors. And that helps to alleviate some of the adversarial nature of one owner going to another owner and saying, hey, you've done something that's hurt me. You've got a board of directors that is intervening in that situation. Mandatory HOAs also have standardized laws. In North Carolina, there's a Condominium Act that became effective in 1986, and there's an even older one that governs older condos. And there's a Planned Community Act that governs HOAs. In some cases, HOAs formed basically in the mid 60s, but it went into effect in 1999, and it applies to all HOAs formed in 1999 to the present. So the laws are standardized. Judges understand it if you ever had to go to court. So that can provide some benefits to owners. In mandatory HOAs, there are also benefits to you contributing your money to the HOA. A lot of HOAs maintain clubhouses, common areas. Some are just things like signs. A lot maintain the roads. So your money in a mandatory HOA actually goes to maintaining community property. They can also intervene in between neighbor to neighbor disputes in some cases. That can help avoid disputes from becoming too personal. They can also offer amenities. They can have social events, things like that to help draw the community closer. And in some cases, a mandatory HOA can apply and receive grants from the city of Charlotte or from other groups. And of course, those grants go to benefit the neighborhood as a whole. There are also cons, and I'm sure many owners perceive the cons more than the pros, unfortunately, but some of the cons are that it can be expensive. Obviously, if you are maintaining a lot of common areas, that costs money. So members have to contribute assessments to help maintain that property. There is oversight that is your declaration of covenants, restrictions, and conditions, or your declaration of condominium, which is an added layer of documents that owners need to understand and which governs their property. You also have less freedom in some cases. To live in an HOA, you're essentially saying, I'm giving up certain of my freedoms. In turn, you're getting some freedoms as well, or at least you're getting some rights. You're asking your board of directors to collect money from owners to maintain property, things like that. You also have low participation nowadays. An HOA was intended to be really a source of government at its most fundamental level, where owners show up at meetings and elect their neighbors to run the community, and you have meetings and discuss the neighborhood issues. Nowadays, it's hard to get anybody to volunteer their time. Enforcement can sometimes be costly. If you have to hire an attorney and go to court, that can certainly add up. On the other hand, you are pooling your money as owners, so it's not as expensive as if you, as an owner, hired your own attorney, since you're sharing the costs. There are, unfortunately, strict penalties if you don't pay your HOA fees. I mentioned liens and foreclosures, so that does happen. The final thing is that HOAs are limited to those people that are subject to the declaration. If certain property is described in the declaration, those people within that property are the members of the HOA. Non-owners are not members of that HOA, so it really has a limited scope. Oops. So voluntary HOA participation has pros and cons, and some overlaps with mandatory HOAs. Again, collective voices are louder. You generally have lower membership fees, but in turn, the voluntary HOA is usually not providing as many services. It's usually not maintaining as many common areas, or maybe even any common areas. It can be inclusive. Oftentimes, if you live in a different neighborhood, you may not be able to participate in a different neighborhood's HOA. For example, and I'm just using this as an example, I can't speak to it personally, but if you don't live in Plaza Midwood, then the Plaza Midwood Homeowners Association may not allow you to be a member. That can be a pro or a con, depending on what you want to do. You may also be able to qualify for grants and get funds to benefit your community. So that's a pro. There are several cons too. You don't have the same legal strength as a mandatory HOA. And what I mean by that is a voluntary HOA cannot file a lien. It's harder to enforce what it wants against an owner. You also have participation that may be lagging. If you don't have people willing to volunteer their time, it's really hard to get much done. Since membership is optional, there's also limited options to increase revenue. If owners are not participating, then obviously your revenue is not going to increase over time. But let's get into the heart of why we're here today. Some HOAs and condominiums have implemented measures to help regulate corporate ownership within the communities. I would say that the primary example is that a lot of condominiums and HOAs, and these are mandatory HOAs, just to clarify, have implemented rental caps. And what that is it literally places a set amount on how many lots or units can be rented at a given time. A frequently seen cap is 10%, but it just varies from community to community. It certainly helps to keep the percentage of the neighborhood owner occupied as opposed to investor occupied or investor owned. But on the negative side, it can also limit the availability of housing. As we've all seen in this area, housing prices have gone through the roof over the past few years. So it does serve to limit the availability of rental property. Another option that mandatory HOAs have considered are occupancy requirements. And what do I mean when I say occupancy requirements? I'm really saying that before a house or a unit can be rented, it has to be occupied by an owner for a certain amount of time. And the reason that a lot of corporate owners may not like that is if you're an investor, you probably are not going to live in that property. You're buying it with the intent to immediately rent it out so that you can get revenue from those from the rental fees. So a lot of corporate owners are not going to be willing to do that. And in turn, that encourages a greater percentage of owners to occupy their lots or units for a certain period of time. The reason you would have an occupancy mandate as well is it helps to avoid a hardship where an owner, let's say, buys a property intending to live there for 10 years, but they have a change of their job or they have a health issue. If they've lived there for a certain amount of time, then they may be exempt from the occupancy requirement. A typical occupancy requirement is 1 year to 2 years. So that's often what HOAs or condos are adopting. And you sometimes hear the term grandfathering. And this is a term where existing owners may be exempt from the rental restrictions that are put in place. And that's basically a technique to get additional participation. And it can also help with a legal challenge if one arose down the road. And why do I say that? Part of the reason I say that is some of these rental restrictions are untested in the courts. We do not have a lot of appellate law telling us what an HOA can or cannot do. There's a very important case from 2006, which is referred to as Armstrong versus Ledges. And in that case, essentially a court said that owners who had enacted a declaration of restrictive covenants governing their neighborhood had exceeded the authority that was in their original documents. But there's an important quote in that case which suggests that restricting rentals may be permissible in certain cases. And the terms that we as attorneys typically use when judging whether a rental restriction is reasonable or is enforceable is whether it is reasonable. That's the nebulous term that our courts have given us. Unfortunately, it's really hard to give a specific answer to what's reasonable, but that's what our courts tell us. HOA attorneys that I've spoken with really throughout the state have opined that we think these types of rental restrictions are generally enforceable. We generally think that caps on the number of rentals are enforceable, that occupancy requirements are enforceable, and certainly the grandfathering provisions are also enforceable, and that's really more of just a technique to gain additional participation. There is often less of a legal concern for a non-mandatory HOA or for deed restrictions that I'll talk about in a minute. And the reason that there's less of a legal concern is that if you as an owner agree to restrict your property in some fashion, it's harder to challenge because you're the one who's agreed to it. At least in a mandatory HOA, you could argue that even though a certain number of owners have approved a rental restriction, if you didn't buy into that rental restriction, you may say that it's unreasonable to you. But if you put it on your own property, that argument doesn't exist. I've got some sample language in here. I'm not saying to copy it. I'm just providing this for illustrative purposes for what some HOAs use for a occupancy restriction. And it basically boils down to that the property must be occupied by the owner of an LLC or a corporation for at least 1 year before that owner is eligible to rent. I've also got some sample grandfathering language. What we typically say for grandfathering is that as long as title to the property remains in the owner at the time the rental restrictions are put in place, as long as title remains in that owner is exempted from whatever's in the rental restrictions. So for example, if you impose a 10% cap on rentals, but there's already, let's say 15% of lots that are rented, then those 15% are exempted from the cap. The cap only comes into play if a lot changes ownership. So we'll talk about deed restrictions. And by deed restrictions, that's really a more historical term, but what it really comes down to is that somebody records something in their deed or against their property that restricts how their property is used in the future. In Mecklenburg County, going back to probably 1910, a lot of developers put in place deed restrictions governing entire neighborhoods. There was no such thing as an HOA or a condominium back then. So what a developer would do is they'd say, okay, I own 10 acres of land. I'm going to say that all houses must be a certain square footage, or no businesses can be built on any of these lots. And since it was in a document governing those entire 10 acres, every one of those lots that were carved out of that 10 acres was bound by it. So it was said to run with the land. Recall, that's the term I mentioned earlier. One of the cons of this legal structure is that there's no governing body. There's no HOA to tell people what they can do with their property. If your neighbor wants to build something in violation of the deed restrictions, it's up to you as an owner to try to enforce the deed restrictions against that neighbor. So let's talk about how to implement rental restrictions. And we'll talk about not mandatory HOAs, but let's talk about in voluntary HOAs or deed restrictions. And what an owner would need to do is record a document that runs with the title to that owner's property. And that just means it is a recorded document. Whoever buys that property is subject to it. It's referenced in the chain of title. There also must be at least one benefited party or property. And that may be confusing on its face, but what I mean by that is that you have to have someone who's benefited by a deed restriction. And an example is, if I wanted to record a deed restriction, and let's say I lived in Myers Park, I could potentially say, I'm recording this deed restriction and Myers Park Homeowners Association can enforce it. That would potentially be enforceable, and that illustrates what I mean. I could not just say my property is restricted to residential use, but it can be enforced by anybody in the world. That would not hold up in court. So you have to have someone identified in that document who could enforce it. As many people are aware, there are also other restrictions that you frequently see that affect a property. And I alluded to this earlier in historical deed restrictions, but also, as most people are aware, condos and HOAs, mandatory HOAs, also have similar restrictions in many cases. It requires oftentimes owners to maintain their property to a certain standard. They must regularly get their house painted or maintain their yard. You cannot build a certain type of structure, for example. A lot of times what you see is that houses can be no more than 2, or you sometimes see 2.5 stories in height. You sometimes see restrictions against operating a business on a property. And these types of provisions could apply really to voluntary HOAs or to mandatory HOAs or to deed restrictions. It's really up to, in many cases, the developer created the initial restrictions, but as we'll talk about in a minute, owners can sometimes change those restrictions. So how do we do this in an HOA or a condo? If members of an HOA want to enact restrictions against rentals or corporate ownership, what they would do is amend their declaration. And there may be a few exceptions out there, but the general rule of thumb is that at least 67% of all owners in the neighborhood have to approve of the amendment. And that's a high threshold. When I say 67%, I don't just mean 67% of people who show up at a neighborhood meeting. I mean 67% of all owners. So that's a high threshold, and the law wants it to be high because you don't want a neighborhood to be able to change its restrictions with relative ease. You want it to be something that requires a significant number of owners to participate because it's such an important decision. One concern that HOAs and condos face is whether corporate ownership is too high to really affect an amendment. In some communities, there may already be 15, 20, 30, maybe even higher percentage of corporate ownership. That's very difficult to get an amendment at that point because oftentimes, at least in my experience, a lot of those corporate owners don't participate in the governance of the community. One of the strategies, again, is to implement grandfathering provisions because a corporate owner at that point may be incentivized to actually participate because they're exempt from the rental cap. So let's talk about the other kind of restrictions for either voluntary HOAs or deed restrictions that individual owners could put in place. This has a very, in fact, the highest threshold you could possibly imagine. Every owner who wants to implement deed restrictions or to subject themselves and their property to a voluntary HOA has to agree to it. There's really no exception. You really have to have 100% agree to it. And going back to my earlier example where there's 100 lots, if you have 99 owners agree to it, that 100th owner is not bound. One of the pros is that you could have deed restrictions implemented on literally a lot by lot basis. If you own a lot, you could put a deed restriction in place on your lot. You could do that. I'd recommend hiring an attorney, but you could hire an attorney who drafts up a document and records it against your property. The problem with this is a lot of times owners want other owners to agree to rental restrictions, but they don't want it to apply to their property. And that, in my experience, is just human nature. People may say, well, I don't want there to be a lot of rentals in my neighborhood, but if I have a hardship later on and want to rent my property, I want to have the freedom to do that. So you get a lot of times where people think it's a good idea, but they're unwilling to commit their property to it. So the city of Charlotte has a number of opportunities out there, and these are not necessarily specific to this presentation, but they're things that neighborhoods can consider either for other projects or, as was mentioned earlier, I think the city is considering its options and whether it could provide further resources. And certainly after my part is done, I can have the city speak to this. I don't think I'm speaking out of turn, but they could address this more if necessary. But there are matching grants out there for up to $25,000. There are usually specific programs that you would have to apply to, but I've certainly seen in my experience, a lot of grant funds go to HOAs, condominiums, and just community associations in general. So that's something all communities could consider. There are liaisons who can help with problem solving, can interface with residents and ultimately steer them to discussions like this for them to make decisions and empower themselves if they are interested in doing so. There's also counseling, down payment assistance, and rehab programs. So those are all city and county funded options. There's also tax relief that may be available to people facing tax hardships. So those are resources that are available to owners and certainly maybe to HOAs, condominiums, and community associations that are voluntary. There are also a lot of on-demand topics that you can use to educate yourself and learn more about topics similar to tonight's topic, but also on various other topics. I'm not sure if this is all of the ones that are out there, but this is certainly a very comprehensive list. I believe, as was mentioned earlier, you have access to these, and I think Nicole could probably provide you additional information on how to access some of these topics. So I realize I've covered a lot of ground pretty quickly, and I'm intending to answer as many questions as people have, and I think we have allocated up to 7:30 if we need it, assuming I haven't put most of you to sleep by this point. But mandatory HOAs have a significant ability to regulate or at least deter corporate ownership. They do that primarily through rental caps or occupancy requirements. Mandatory HOA formation is very difficult, and that's because you would need 100% of owners to agree to do it. There are also options other than mandatory HOAs. There are community associations, I've mentioned a number of them tonight, that you can look into joining that collectively speak louder than most owners individually. Or you could also record deed restrictions against your property. I think deed restrictions would probably be most effective if a group of owners agreed collectively to record similar deed restrictions against their property. But again, it could be done on a lot by lot basis. And finally, there are a number of resources out there that you as owners or members of HOAs or condominiums or even voluntary HOAs can consider looking into to see if there are resources available. And I certainly encourage you to follow up after this presentation to see if there are follow-ups, because I think there will probably be additional discussion. So I have gone over a lot really quickly. I think unless Nicole or Sean wants to add anything, we could probably shift into a question and answer session.
And I'd love quickly, we've got just a couple of polling questions to help us understand who is in the room tonight and help us consider who's showing up to receive education on this topic and similar topics. So if Philip Freeman is available to share that with us, if you all are participants wouldn't mind responding to just these two quick questions. So the first question seeks to learn about your neighborhood organizational status currently. And so if you would just select the option that most closely resembles your current neighborhood organizational structure, and your choices there are a legally mandated HOA, a voluntarily organized neighborhood or community association, or no current organizational status in your neighborhood. And we're still seeing those answers come in, but it looks like the majority of participants tonight are members of a legally mandated HOA. Great, thank you for that feedback. And Philip, next question, please. And this question is specific to those persons who responded that they are currently part of a legally mandated HOA. And again, as we consider additional education and resources, I'd like to understand if you are just learning about this topic tonight and that's what brought you out, or if you've already met as an organization and you and your neighbors are aligned and desire to move forward with amending your bylaws. And then also out of curiosity, is anybody on the call who has already amended their bylaws? And this would be specifically an attempt to deter corporate buyer interest. All right, so it looks like we're seeing over half of us here just here to learn, and we appreciate you coming out to do so, and we're learning alongside of you. And also about 33% that has already met with the intention of pursuing an effort to amend their bylaws for this purpose. So thank you so much for sharing that information with us. We do have a number of questions that have come forward. And again, as a reminder, feel free to place your questions in that Q&A chat. You should see that button on the bottom ribbon of your screen near where you mute and unmute yourself. Feel free to include your questions there. I'm going to start with some previously submitted questions, and then we'll move to that Q&A box. So Ben, coming at you. Is it easy for a neighborhood that's not currently organized to form an HOA to deter for the purpose of deterring corporate buyer interest?
Well, that's a loaded question. If owners are intending to form a mandatory HOA, and recall a mandatory HOA is one where people are obligated to pay assessments to the HOA, then you really need 100% participation. If owners are interested in forming a voluntary HOA, then the barrier is much lower, but it's harder to enforce any sort of restrictions. If you have a true voluntary HOA, then it does not govern any of the real estate. It's really more of a loud voice, but it does not give an owner or it does not give that voluntary HOA the power to, say, prevent a corporate owner. So it sort of runs the spectrum there.
Thank you. Does the city or my own neighborhood have ability to go after corporate investors specifically by creating rules or laws that prohibit persons from selling to a corporate buyer, or to place conditions on that sale that would control what the corporate buyer does or how long they're able to own the house for?
Well, we covered some of this, and just to clarify, there's probably no right to prohibit someone from selling to a corporate owner. But what a mandatory HOA has the ability to do is to restrict what that corporate owner does with the property for at least a certain time period, or maybe altogether if there's a rental cap. So you really cannot prohibit someone from selling to a corporate owner, but you can regulate what that corporate owner does with the property.
Great. And follow up to that question, could I, as an individual property owner, refuse to sell my property to a corporate buyer?
Yes, generally, and I'm going to put an asterisk in my comment here, generally you can sell to whoever you want to, or refuse to sell to whoever you want to. But the asterisk there is you cannot do it if it's discriminatory. Just to make clear, you could not say, well, I'm not going to sell to a person of a certain religion, for example. Those are protected classes. You could not choose not to sell based on a protected class, but you generally have freedom of choice. If you don't want to sell your property, you don't have to. No one can force you to sell it. But what we see, or what we've seen here in Mecklenburg and Charlotte over the last few years, is that corporate buyers are willing to pay above market prices, and there's no loan contingency or anything. They're essentially paying cash. So that's hard for some owners to pass up.
Thank you for that response. If I'm currently in an unorganized neighborhood, is there any ability for me to establish control over my neighbor's property without their approval via protective covenants or some other measure?
Generally, no. And as I mentioned earlier, you really want 100% participation. You could not force your neighbor to agree to something that they don't want to, as far as recording a declaration or say, if they don't live in a mandatory HOA, you could not force your neighbor to become part of a mandatory HOA. There are deed restrictions in some cases, in some neighborhoods that go back at this point over 100 years. They may be enforceable. If they are, they may restrict what your neighbor can do on their property. So for example, you may have a requirement that a house be a certain square footage, or that lots could not be subdivided into smaller lots. So there may be options. It varies from neighborhood to neighborhood. So you would really need to have an attorney do a title search and see if there are deed restrictions that impact your property, and if there are, what rights you have under them.
Thank you for that information. This question is coming from the perspective of somebody that is in a mandatory HOA currently, and they're asking if the city could intervene to amend their HOA CC&Rs to prohibit or deter corporate buyer interest.
There is no option that I'm available for the city to do that.
And again, another question coming from somebody in a legally mandated HOA. They're asking what the rules are for their neighborhood to amend their own CC&Rs.
So I cannot answer that specifically to that neighborhood, but generally the rule of thumb is 67% or more of all owners. In some documents, it says, for example, 90% of owners have to agree. And the law says that that's fine. It just can't be below 67%. So in some neighborhoods, it's as low as 67%. In some, it's much higher.
Fantastic. And moving on to our Q&A questions. And again, I thank you to each of you who has submitted a question. Feel free to do so. Our first question and the Q&A comes from Denise C. And she is asking, can corporate owners or investors be charged a higher HOA fee or a one-time significant fee to deter their purchase?
My position is generally no. What the law essentially says is that all owners have to be charged a uniform rate, at least in a mandatory HOA. The rate in some condos differs, and the reason is that condos can set up a structure where certain owners have to pay more just based on the value of their condominium unit or the size of the condominium unit. But generally speaking, no, you could not require a corporate owner to pay more than a non-corporate owner.
And Tony is asking, what is the name of the last litigant in the Armstrong case?
It was, I believe it was Ledges. I may have the name wrong, but it's Ledges Community Association, or something along those lines.
And we can definitely follow up if you need a more specific response. Thank you for that question, Tony. Audrey is asking, how does one get a legally mandated HOA involved to make changes to restrict?
Well, there are several ways. For a mandatory HOA, really the board of directors should be taking the pulse of the members periodically. And what that means is having members attend board meetings to give feedback, taking feedback at annual membership meetings, and ultimately helping the owners carry those forward. And if owners are interested in amending their documents, then the board should certainly consider it. Many boards also are really on the front edge of a lot of these topics. So a lot of times boards are really ahead of the owners generally. So in my experience, boards oftentimes are saying, look, we need to address some of these rental issues. Let's figure out what we can do. So it's basically either membership driven and your board should listen, or it's board driven and boards are presenting some of these ideas to the members.
Thank you for that response. Ms. McCarthy, there's a request in the chat for a little bit more information to be able to answer your question. And Dennis is asking, how can the city of Charlotte help older neighborhoods understand the ramification of the Marketable Title Act and recent NC court decision, which eliminates deed restrictions that are over 30 years old?
Well, this is a loaded question. The basis of the question is a series of 3 lawsuits, which came out fairly recently. The Supreme Court opined, I think in the last 2 months, that certain older deed restrictions are extinguished if there is basically a 30-year gap in the chain of title. And what happened is there's a neighborhood in Charlotte where there were deed restrictions recorded in, I believe, the early 1950s. And the legislature at some point enacted a law called the Marketable Record Title Act, which says that if your title does not reference a deed restriction for more than 30 years as to a specific property, then that deed restriction is stricken as to that property. So in the recent Supreme Court decision, there's a neighborhood in Charlotte where I don't know all the facts, but a developer bought a number of lots. And from what I understand, some of the neighboring owners were unhappy that the developer wanted to do something with their property. I'm not sure what they were intending to do, but they ultimately neighbors sued, and this Marketable Record Title Act was deemed to strike the covenants or the deed restrictions from at least the developer's property in that neighborhood. That's certainly something that I don't know what the city or county or anybody could do as far as getting the word out about that case. It certainly got some people here in Charlotte very concerned that restrictions that have been in place for 100 years may all of a sudden be nullified. I also suspect the legislature will probably intervene. I can't say for sure, but I would assume they'll intervene and help clarify what the Marketable Record Title Act does and does not do, at least for HOAs and condos. The legislature last year, expecting that perhaps this case would impact HOAs and condos, and when I say HOAs, I mean mandatory HOAs, said that as long as an HOA or a condo is incorporated as of July 2022, that the Marketable Record Title Act does not impact their declaration of restrictive covenants. So there was at least a fear for a time period that HOAs and condos would have their documents stricken, but the legislature intervened. So that's all I can read. I probably said too much about that case, but that's the state of the law right now.
That was the $2 answer for sure. Really interesting question here from Hermes. I might be saying that incorrectly. Our original CC&R says simple majority is all that is needed to amend CC&Rs in every 10th year. Would this be obsolete or in conflict with the 67% requirement in state law?
Well, it depends. Some older restrictions have a less than 67% requirement, and sometimes that can be enforceable. So in some older communities, they may be able to amend with a threshold below the 67%. As far as the every 10-year requirement, that really depends on the very specific language that the documents use. There's an old case which said that at least in one HOA that the developer essentially said you can make amendments once every 10 years or something along those lines, and the court upheld that. That decision is, at least in my opinion, somewhat challengeable nowadays. I think that decision came out 20 or 30 years ago, so I'm not sure if the courts would interpret the law the same now as they did back then. But simple answer is you would need to look at your specific documents, probably with an attorney, to see what they allow and how frequently amendments could be made.
Hadn't seen that come up in CC&Rs. That was a really interesting question. Additional clarifying question. For the 67% that state law requires to amend CC&Rs, would that 67% include any corporate owners that are already within the community?
Yes, it includes all current owners. You need corporate and non-corporate owners collectively making up that 67%.
And a question here from Ron about voluntary HOAs. If you had a voluntary HOA situation or were a private property owner and you did self-impose that deed restriction, would the deed restriction get canceled after the property is sold? And additionally, can a deed restriction be enforced by a designated family member?
So this is a multi-part question. Let me try to address it in its individual parts. If you subject your property to a voluntary HOA or to deed restrictions, really, the purpose is that they are intended to run with the land so that it would bind future owners. That's the whole point. So you would build in a requirement that the deed restriction and the requirements in it transfer to future owners. So the goal is that someone, 10 owners from now still can't rent, or at least is subject to whatever you recorded today. Then the second question is, can a deed restriction be enforced by a designated family member? And that's sort of a loaded question. And I don't want to get too far into the weeds, but the answer is probably yes. A designated family member could enforce a deed restriction, but what happens if that family member passes away? There's at least a line of cases out there which says that those type of restrictions are personal. They're owned by that person who you designated, and if that person is no longer living, then it's not enforceable at all. So if you designate a very specific person, you're sort of asking for trouble.
That was another great question. Thank you. Our HOA of 2 people have become complacent and have neglected their fiduciary duties to homeowners. Our neighborhood, which is predominantly minority, has more than 50% of the properties now owned by corporations. Our property values have gone down 15% in 3 months and are still declining. We vote, but the HOA says that we don't meet quorum. How can we, when the owners, some don't even live in this country, have violated the rules to our bylaws? What opportunities do we have?
Well, this is a question with a far-ranging answer, and it sort of governs some of the pros and cons of mandatory HOAs. What I think the person asking the question is suggesting is that there's not a lot of participation in the HOA overall, which is certainly a problem, and I encourage everybody to get involved. I think the owners or the questioner is also saying that the board of directors may not be acting in accordance with the law. That I can't speak to. The Planned Community Act, which is General Statute 47F, which was specifically referenced in the question, it's actually a consumer protection law. So there really are provisions that are intended to allow owners to have transparency and to have a voice in the governance of the association. But in turn, it usually takes a certain number of owners to actually make the board hold meetings and things like that. A typical threshold you see is 10%. So that if 10% of owners can essentially sign a resolution asking the board to do something, usually to call a meeting, then that's usually how you would prompt the board to do something. The other thing I tell communities, and certainly it's always risky to suggest this, but the answer to most concerns with an HOA that is not functioning how people think it should is for owners to band together and elect a new board. It really takes a lot of volunteers to run an HOA effectively. I deal with boards all the time where it feels like the only time the board gets participation is if they increase the assessments due to rising costs. People get incredibly bent out of shape over what are essentially minor increases in assessments But then when you ask people to vote on something like rental restrictions, they don't even open their mail. So it's really hard for a board to get participation. What I would encourage everybody who lives in a mandatory HOA, and certainly in a voluntary HOA as well, is to get involved. The whole purpose of an HOA is for governance. So I'm sorry, it's for participation. So you'll have democracy at its smallest, most basic level. So I'd encourage everybody to get involved.
And one item in that question that stood out for me was the participant indicating that their board only has 2 members. Does state law mandate how many members an HOA must have for a mandatory HOA?
Yeah, and to break this question down, I think the person asking the question is suggesting that the board of directors only has 2 members on it, not that the HOA as a whole has 2 members. By law, a nonprofit corporation, which is a condominium or a mandatory HOA, has to have a board of at least 3 people. But a board could theoretically operate with 2 people if it cannot get a third. This is also a question which each community has different requirements. The law requires a minimum of 3 directors on the board, but it could go up to 5, 7. You know, it could go up really higher if that's how the documents are prepared. So it may not be in violation of state law that there's only 2 people on the board of directors, but there could at least be 3 or more.
Thank you for that response. We are getting some pretty detailed questions in the Q&A specific to what sounds like challenges or disagreements with the board. And I just want to keep us high level that our focus tonight really is providing education to support neighborhoods who have chosen to attempt to deter corporate buyers to do so. And so I'm going to bring us back to that. And also for anybody who is not aware, the city has no legal authority to intervene in mandatory HOA matters. And so as much as it really breaks our heart to hear people arguing in the communities and that we have empathy for that, there's not much that we can do to resolve disputes as they pertain to mandatory HOAs. That really is a private legal matter. And that's why people like Ben stay in business and stay so busy. Because they are the appropriate resource to vet those challenges. An additional question in the chat is, will we be provided a copy of the slides? Absolutely, we will provide a copy of the presentation. Additionally, as mentioned, this workshop will be recorded and available in our City of Charlotte on-demand training library. Those other 9 or so topics that have been mentioned around HOAs are already existing in that on-demand training library. You can easily Google that just by going charlottenc.gov and typing on-demand training. Additionally, a link has just been put in the chat to that on-demand training library. There was another question for Ben's contact information. Philip, who is assisting us tonight, who not only provides incredible tech support, but also runs our neighborhood resource and training group, will actually be the appropriate contact for follow-up. That'll help us to corral the questions, understand what needs there are, and to understand if we need to just source one-off answers for you, or if we'll need to plan another training contact. So if you would, please refrain from contacting Ben directly. He's been so generous with his time tonight, but I don't want to direct people to reach out to him directly unless you're contracting him for legal services. I'm not currently seeing any additional new questions in the Q&A, so I want to just once again invite any additional questions. I'll also point your attention to Philip Freeman's contact info in that chat box if something strikes you as you're able to reflect on this content tonight. As we've heard repeatedly, it's a complicated, if it was a Facebook status, it would be, it's complicated. It's really challenging to work through this, and we appreciate the city's support to help neighbors understand their options, and Ben and his support to help explain what is a very challenging topic to vet through. We'll give just another moment if anybody is typing a question in the Q&A. And in not seeing any additional questions, I certainly want to thank all of you, not only for your time this evening, but for caring so much about our neighborhoods. Our residents really are the best part of the city of Charlotte. We hope that you'll join us for additional training topics and that you'll continue to reach out to our team to help us know what topics are of value to you. We will continue to share resources as they come available. I want to thank Sean Heath and Ben Karb and Philip Freeman for their support this evening. And with that, we will conclude our workshop tonight. Thank you.